Hi, everyone. Thank you so much for joining us. My name is Dustin Saldarriaga, and I'm an immigration attorney with Scott Legal PC. Today, we're spending some time talking about the EB-2 National Interest Waiver, or NIW. This is a green card, and it's an underutilized category. And we've started to see more and more people using it, especially entrepreneurs. So today we're very fortunate to have my colleague Jiyae Hwang speaking with us. Jiyae is a senior associate at the firm, and she has extensive experience preparing EB-2 National Interest Waiver petitions. A few things before we get started. Our firm is a full-service immigration firm, so though we do focus on business immigration, we also handle family immigration, humanitarian law, really the full spectrum of immigration issues. So please don't hesitate to reach out to us if we can be of any help at all. We will be continuing this webinar series. We try to do at least 2 webinars a month, and we do them on a variety of topics. At the end of the webinar, we'll be sending you an email where you can sign up for our future webinars, and we hope you'll do that. We'll also be sharing a comprehensive guide to the NIW, as well as a link to our YouTube channel. We are recording this webinar, and we post our webinars as well as a variety of shorter videos to our YouTube channel. And these really do run the full spectrum of topics within U.S. immigration law. So please do check that out. If you have a question during the presentation, you can either send it to me through the Q&A function on Zoom or through the chat function. And I will be actively monitoring both. And I'll either share your question when it comes up or at the end of the presentation, just depending on where we are in the conversation. Again, the presentation is being recorded, and please do keep an eye out for our follow-up email where we will send a link to the recording as well. Without further delay, let's go ahead and dive into our questions. This is a Q&A format presentation, and let's start with a broad question about the NIW. What is a National Interest Waiver, Jiyae, and what are the reasons why someone might consider applying for an NIW?
Yeah, thanks so much, Dustin, for the kind introduction. So yeah, let's dive right in. The NIW is short for National Interest Waiver, and it is a subset of the EB-2 employment-based immigrant petition, right? And so an immigrant petition here means that this is an application for a green card, a U.S. permanent resident status. And so there are many reasons why someone may want to apply for a green card, right? A green card gives someone the ability to live permanently in the United States and work for any employer or not at all. So it gives a certain degree of freedom to a person. And having a green card also opens up the way to U.S. citizenship down the road. So NIW is popular among individuals who want to apply for a green card on their own. And by that, I mean self-petitioning, right? So not petitioning for a green card through an employer sponsor, but on their own. And NIW is one of the rare ways where someone can actually do that on their own. Normally, you would need a US-based employer to do that. EB-1A is another category that allows self-petitioning, but it is less accessible than the EB-2 NIW because for the EB-1A, you really need to show that you are at the top 1% of your field, whereas for the NIW, the standard is different than that. And so another advantage of the NIW is that it is less time consuming. So usually when you're being sponsored for a green card through an employer, you would need to go through the labor certification process. Well, your employer would need to go through that. And that means the employer is testing the US labor market to see if there's a US person who has the minimum qualifications that you have that can take the job in the place of you. But for the NIW, you don't need to go through that process. So it significantly shortens the time towards the green card for people that qualify. Now, it is also worth noting that premium processing has expanded to include NIW EB-2 petitions. So NIW has become one of the fastest ways, actually, an individual could be approved for a green card. You will receive a decision as fast as 45 days. And in practice, we have been getting decisions even quicker than the 45 days with premium processing. So you could get an answer on the I-140, which is the underlying petition, very quickly. However, it is worth noting, though, that that every month the Department of State publishes a visa bulletin, and in the visa bulletin you see whether a certain category of visas are oversubscribed or is it current. And unfortunately, there has been a backlog, a retrogression in these states. So even if you have an NIW approval, it could be a little bit of a wait before a visa is available, so that you can either apply to adjust status in the United States to a green card holder or to apply for an immigrant visa in your home country. So that delay is something that people should keep in mind when they consider an NIW.
Perfect, thank you. And so why don't we take another step back and talk about what are the requirements for an NIW? How do you qualify for this?
Yeah, so very important question, right? So there are two things that I want to discuss. The first is the threshold requirement to qualify for the EB2 category in the beginning. And there are also a three-pronged matter of Danazar test where you have to meet all three prongs to show that you qualify for an NIW. So let's start with the threshold question for qualifying under the EB2 category. So you can meet that threshold through two ways. The first way is the most common, is through showing that you have an advanced degree in your field. And what does an advanced degree mean? It means a master's degree or above in your field. So Master in Science, Master of Arts, that all qualifies. PhD degree in science, PhD degree in arts, PhD degree in business law, all of those can qualify. An MBA could also qualify, a Master of Business Administration. A JD could qualify, a Juris Doctor, if you are a lawyer, because you do need a bachelor's degree to get into a JD. In a similar vein, if you have an MD, a medical doctor degree, you could also qualify under the advanced degree threshold, because you do need a bachelor's to get to an MD program. Now, it doesn't need to be a US degree, but you do need to have a US education equivalency report that confirms that your foreign degree is equivalent to a US degree of the same level. So that is a caveat there if you have a foreign degree. Now, what if you don't have a master's degree or above? Another way you could qualify as having an equivalent of a master's is if you have a bachelor's degree in your field and over 5 years of progressive work experience. And what does progressive work experience mean? It means that your duties have changed over time to include more senior and complex duties. So it wouldn't work if you have worked in one position and your salary has stayed the same, your title has stayed the same, and your duties have stayed exactly the same, and you have just worked 5 years, combined with a bachelor's degree that will unfortunately not qualify as an equivalent of a master's degree. But let's say you started off with a junior associate, and then you became a senior associate, and then you became a partner within the 5 years. Those changing duties and changing titles and changing seniority of your positions could support a finding that you have 5 years or more of progressive work experience. And combined with a bachelor's degree, that can also count as equivalent of a master's. Now, if you don't have a bachelor's, or if you have a bachelor's, but if you only have 3 years of experience, for example, and you can't use the bachelor's plus 5 years channel, there's another way you can qualify for the EB2 threshold, and that is through exceptional ability. Now, exceptional ability is defined as a level of expertise that is significantly above that is ordinarily encountered in the field. So that's, to a degree, is sort of a qualitative assessment as well. But there is also a variety of evidences that you are required to have in order to support your case for exceptional ability. So one of that is 10 years of experience in your field. Another criteria is membership in professional associations in your field. Another criteria is licenses that is relevant to practicing your profession. Another one is if you have any related degrees. It doesn't matter if it's a diploma or certificate or something like that. If you have any related degrees, you can also use those as evidences. A high salary, if you command a higher salary than most other professionals in your field, you can also use that as evidence. And most importantly, if you can show that you have commanded recognition in your field for significant contribution to the field as a whole, for example, by awards or being shortlisted in some industry lists or things like that, or publishing any papers or patents, all of those can serve as a support that you have made substantial contributions to your field, and that would be relevant in proving that you have exceptional ability.
Perfect. And so you mentioned EB1 at the start of the presentation.
Yeah.
How is exceptional ability, what you just described, different from extraordinary ability?
Yeah, so it is definitely a good idea to sort of go over that before we move on to the matter of Danazar factors. So exceptional ability is a lower standard than extraordinary ability for an EB1, right? And I also want to make sure you understand, well, everyone understands here that you only need to use exceptional ability if you don't have a master's or if you don't have the bachelor's or the 5 years. So in many cases, we don't even need to go there and go through the analysis of significant contributions to the industry. But yeah, so the operative language here is a degree of expertise significantly above that is ordinarily encountered, but it's different from the EB1A standard where you need to show sustained national or international acclaim, showing that you're one of the small percentage that have risen to the very top of your field of endeavor. So that's already, you can see that it's a completely different language that the regulatory standard is looking for. As long as you can show that you're one of the leaders, well, not someone who's like the top 10 of your field, definitely not, but if you have made certain advances in your field that has been recognized to a certain degree, by industry level recognitions, it can be through any localized awards, or letters of recommendation from relevant associations or individuals. All of these things can be relevant in showing that you're one of the higher 50%, as different from, as distinguished from the ordinary in your field. So as long as you can show that level of contribution to the industry, you could qualify for the exceptional ability. But for EB1, you will need to definitely show a more outstanding performance than that.
Great. And so maybe it would be helpful at this point to use an example and show how someone has actually satisfied the requirements that you talked about.
Yeah, definitely. So let's look at a case study. Now, let's look at a case study where an NIW was approved for an entrepreneur who set up a small consulting firm. And just to go over the threshold requirement, this person had an advanced degree, a master's degree or above, so they were able to meet the threshold that way. Now, importantly, though, to qualify for a national interest waiver, you need to satisfy what is called a three-pronged matter of Danazar test. The first prong of the matter of Danazar test is that your proposed endeavor in the United States have national importance and substantial merit. And really, substantial merit can be shown in a variety of industries, but national importance is the key, right? So what the government is looking for is what are the impacts, what is the potential impact of your endeavor, and does it go beyond your immediate clients or employers, but it affects the field as a whole in a positive way, or affects the society in a major way. Now, the second criteria for the matter of Danazar three-pronged test is that you yourself are well positioned to advance this endeavor. And this can be shown by a combination of your education, your experience, really a relevant record of success that you have in that relevant area that gives you the skills, the knowledge, the know-how to really make sure that this project is successful. And the third category is really a balancing test. Given the benefits of your work, given your unique skills and experiences and knowledge that cannot be found in the general body of practitioners, does it really benefit the United States to exempt you from the labor certification requirements such that you're allowed to come into the US and start your work immediately? So looking at a case study, right? So for this case, the entrepreneurs proposed to set up a small consulting firm, and the focus of that firm was to coordinate projects aimed at improving the quality of services given to U.S. veterans and veterans' families, and really helping veterans be connected to job opportunities, because the gap in the industry was that veterans, especially if they were wounded, they were having trouble finding appropriate employment opportunities to really get back into productive society, right? So that was the proposed endeavor there. And the proposed endeavor was very developed and detailed. This person, prepared a very detailed business plan where they set out a plan of how he would coordinate organizations and projects to facilitate the reintegration of the veterans into productive society. So there were some specific mentions of what kinds of organizations he would work with, relevant philanthropy organizations, relevant government organizations. And the business plan was also supported by letters of support and intent to collaborate by these philanthropy organizations, government organizations in the United States. So there was a lot of support for these plans. With regards to the second prong, well positioned to advance the proposed endeavor, really the record had a lot of testimony about how this particular entrepreneur had engaged in similar projects in the past. In the UK, that was where he was from. And those case studies had very remarkable successes. So for example, there were letters of recommendation that he got from senior officials in government and philanthropy in the UK, talking about how some of the projects that he led resulted in, connecting millions of dollars in charitable funding from private organizations to productive use through these programmings that he coordinated. And really, there was a lot of testimony about how his knowledge and know-how and network was unique as opposed to, other individuals who would be active in the philanthropy industry. He was a really outstanding player in that regard in the US and UK veterans community. So that really helped in persuading the government that this person was uniquely qualified to really make this project successful. Talking about the third prong then, on balance, does it benefit the United States to exempt the labor certification requirement for this person? The answer was a resounding yes, because, for the first prong, national importance, the benefits that we can expect from his endeavor really was a societal benefit by showing a different way of doing philanthropy that could really help serve as a role model for how veteran reintegration could be envisioned, right? So systemic benefits were expected from his work. For the second prong, it was clear that this person had a high level of experience in relevant projects, and those relevant projects have seen substantial success in the past in his home country. So that really helped in proving that he had unique levels of knowledge and networks that cannot be found from the general body of practitioners. So thinking of these positive benefits, right, and comparing that with the ordinary benefit of saving one job spot for a U.S. person, it was clear for the government that it was more beneficial to have this person come in and do this work that had such broad impacts to the industry and society, instead of the ordinary benefits of keeping that job away from a foreign person.
Perfect. And do you actually need an established company in order to qualify for an NIW, or can you apply with a startup? And if you can apply with a startup as well as an established company, can you talk about the pros and cons of each?
Yeah, certainly. So that is a common question that we get. And the answer is no, you do not need an established company to apply for an NIW. You can apply with a business plan. And so it is a little different from an E2 context where you do need to have the US entity and you do need to have, made the expenditures and things like that. For the NIW is less like that. So you can lead with a business plan, and you can show the traction and interest in the business plan through letters of intent with relevant partners or relevant clients that will work with you once you come into the US and once you start this work. But that work need not have already been started. Now, let's then talk about the pros and cons, though, because we do also encounter cases where, for example, if someone is already on an E2 visa and they have been already operating that business for a long time, many years, in fact. So what about comparing the situation where you would have an established company and you're using that as the basis for your NIW, or as opposed to a case where you're not in the United States even, or if you have an idea for a startup, or if you're a student and you're thinking of a completely new startup and you're applying for the NIW based on that idea. So let's go over the pros and cons of each. So starting with an established company, definitely one advantage is that if you have seen significant revenues and job growth in the past, in the years that you have managed a company. Let's say you're bringing in millions of dollars in revenues every year. Let's say you've already created 20 jobs in the United States. All of those growth metrics can support future projections, and it can be a very good way to establish that you're well positioned to continue running your business because you have been successfully running your business in the past. So this can be good for well positioned. And also another advantage is that you can use some successful cases that you have led through your company. So for example, let's say you're an engineering consultancy and you have completed several high profile projects where the result of this project was a patent that has been published, or the result of the project was an application that uses AI to, make things better for businesses, more efficient, right? And then that has been mentioned in industry shortlist or things like that. Those are successful case studies that you can use to really show that you're well positioned to continue this work, and also that the impact of your work will go beyond just benefiting your clients, but will result in positive impact to the industry, which is very important for national importance as well. So that's definitely an advantage of having a track record before you apply. Now, as for cons, if the business is not doing so well, then that can be a problem, because if, let's say, you've had a company for 5 years and the revenues have just been enough to support you and your family, and let's say you only have 1 or 2 employees outside of yourself. Now, if you're using those projections to project future growth for a company, it could be a little bit of a challenge to show how the benefits of your business activity would rise to the level of national importance. So in that case, really maybe a better idea to come up with a new business idea, or to think of ways to position your business such that it's different from what you have been doing in the past. Instead, you can think about projects that can have a broader impact than what you have been seeing before. Now, for a startup, let's discuss the pros and cons of applying with a startup idea. So the pros of this is that really you're not tied to anything. You can really lead with any idea that makes sense. And as long as the plan makes sense and is credible, then there is really no need to show a history of high growth rates, a history of high revenue generation, or a history of hiring. You can really lead with a plan, and that can be the basis of your argument for national importance. However, for cons, if you don't have a record of related projects that you have already done, or evidence of significant traction in your present project, such as incubator admission or other evidence, or outside VC investment or things like that, there is a risk that your business plan could sound speculative. And that may not be enough to secure an approval for the NIW, because the government is really looking for more than a preponderance of evidence that this is a plausible plan, that there is materiality to this plan.
Perfect. Thank you, Jiyae. So there are a number of questions coming through, largely focused on the process of applying. So why don't we talk a little bit about that? Can you tell us, kind of from just a procedural perspective, how do you apply for an NIW? What forms are you filing? And maybe walk us through the 2 options of applying through USCIS, an adjustment of status, versus a consulate.
Yeah, definitely. That this is a good time to segue into that. So the first step of applying for EB to NIW is submitting the I-140. That is the immigrant petition for non-immigrant, for non-citizen worker, and that is the first step. Now, if the priority date for your category is current, there used to be an option where you can simultaneously apply for an adjustment of status with your I-140. And for adjustment of status, I am referring to the I-485, the application to adjust status to a green card holder. This used to be possible, but actually now it is not possible, because the EB2 and category has retrogressed in terms of priority dates. So what this means practically for people is that you would you would first file an I-140. And once your priority date is current and once you have an approval, there are two options that you can take. So the first option is what I just mentioned, is if you're already in the United States on a different non-immigrant status, you can file your I-485, the application to adjust status to a green card holder. And what this gives you is the ability to continue staying in the United States while your I-485 green card application is pending. And while the I-485 is pending, you can also apply for an employment authorization card and also apply for a travel authorization. So once you have these two things, you can continue to go in and out of the United States if you wish to travel internationally. Normally you cannot while your I-485 is pending. And you can also, once you get the employment authorization card, you can work for any employer you want while the I-485 is pending. So that gives quite a bit of relief for people who are waiting for their green cards, because it can take over a year for green cards to be processed. Yeah, right. So that's one option. The second option, and this is relevant if you're not already in the United States on a different status. So if you're living in a foreign country, or if you are already in the United States, but you want to preserve the ability to travel in and out. So that option is to apply for an immigrant visa through a foreign consulate, a U.S. consulate in a foreign country, in your home country, most likely. And what you do is then you apply for the immigrant visa through filing the DS-260 and other civil documents, and you would schedule an immigrant visa interview at your home country consulate, and you would go attend the interview. And once the interview is passed, they would take your passport, they would give you the passport with the immigrant visa stamp. And once you have the immigrant visa stamp, then you would come into the United States, and that would be your landing in the United States as a permanent resident, and they will mail you your green card to your US address. So that is another way that someone can choose to process the green card. But the underlying application is the I-140, and you do need both the I-140 to be approved and the priority dates to be current in order to go forward with the consular processing. With regards to the I-485, you can file as soon as the priority dates are current, even if your I-140 is still pending. So that's another difference with the two options.
Great, that's helpful. And can you say a little bit about dual intent? A number of questions are wondering,
Sure
when you
thing.
file the I-140, you're, communicating to the government that you do plan to pursue a green card. And so how does that affect you if you have like a TN visa that you're on, and you want to continue working on that and leaving and coming back into the US on your TN? So how do you navigate that?
Yeah, so if you are on a TN, the TN is one of the categories that really scrutinize immigrant intent quite strictly. So even by just filing the NIW I-140, you're already putting your future TN extensions and future TN applications at risk. You can always try to tell the officer when you're trying to come in that you don't intend to adjust status in the United States. Rather, you intend to consular process your green card, such that for the immediate visit, you're not intending to change to a green card holder for that particular visit. You can try that argument, but it is a little risky because not all border officers will accept that argument, right? So there is always a risk that may not work. So once you file the I-140 NIW, you can expect that your subsequent TN applications will be subject to greater scrutiny. So going on with a little bit more on the dual intent, though, the dual intent question is different for other types of visas. So for example, if you have an O1 is a visa that is a little bit more lenient in terms of dual intent, and similar to the O1, the E2, the government has also announced some policy memos where where just the filing of the I-140 will not negate non-immigrant intent for an E2 visa holder. So it really also depends on the type of visas, right? And there has been policy announcement too that says even if an I-485 has been filed, you can still maintain E2 status. So that is huge. So definitely consult with your attorney, because the risk for immigrant intent definitely differs on what type of visa you have in the United States.
Do you know how that would impact an F1, for example, renewing an F1 visa while you have a pending I-140?
An F1 is also a visa that is quite strict in looking at non-immigrant intent. So for example, that could be different. If you have an I-140 and if you're applying for an OPT and you're already on the F1, like that could be okay. But if you're applying for a brand new F1 after you file the I-140, that could be an issue. So yeah, definitely for those questions, yeah, reach out to us, because you really want to look at all the facts.
Perfect. And if the EB2 NIW is for some reason not approved, does it impact existing visas? Like for someone who has a TN, if they file the I-140 and it's denied, does that have an impact on the TN?
No, it does not. So the I-140 stage is not, is the underlying, immigrant visa application, but it will not have an impact on the status that you currently hold in the United States, because it is not a change of status that you're requesting. So that won't affect the visa, well, the status that you currently have. But definitely note that even if your NIW is denied, it does stay on your record. So the government will know that you have applied for an immigrant visa the next time you try to enter on TN, right? So you can expect to be questioned about that a little bit more at the border.
That's really helpful.
Yeah.
And so, Jiyae, just to dig a little deeper into the process of adjusting status.
Sure.
Excuse me, does filing the I-140 in the US provide you with any status in and of itself? And can you remain in the US after you file the I-140?
Yeah, so that is a very common misconception, right? So as I've been explaining before, there are two parts to the green card application. The I-140 is the underlying application for categorization, qualification, and the I-485 is the application to adjust status. Now, just by filing the I-140, that does not give you any further status in the United States. It is completely independent from any changes or extension of your status. So if you just filed your I-140 and your current status is expiring, you do need to find a way to either leave the United States or to extend your current non-immigrant status to a different status, because just by filing the I-140, that does not grant any sort of extension benefits. However, once your priority date is current, right? So you would first need to file the I-140 in this case, in the present atmosphere, because the priority dates are not current for the EB2. So once your priority dates become current, you can go ahead and file the I-485, which is the application for adjustment of status. And once you file the I-485, then you are given status to continue staying in the United States. So you don't need to leave the United States. Well, actually, you shouldn't, because once you leave the United States after your I-485 has been filed, then it means you abandon the application. So you do need to stay in the United States once you apply for the I-485. But the upshot is you are able to stay. So you are able to remain in the United States up until you get the decision on the green card. So definitely keep in mind the differences between the I-140 and the I-485. There are two different things, and you cannot simultaneously apply for both in the present climate, because there is a little bit of a backlog in the priority dates. So that is a very important concept to make sure that you understand.
Good. And so when you're referring to the current climate, it really is the visa bulletin,
Yes,
right?
it is. Yes.
Yeah, so for anyone listening, if you want to check, you can Google the visa bulletin, most recent visa bulletin, and you can see for the EB2 category whether it's current, whether there's a C. And since it's not, you can't file your I-45 at the same time. So just to quickly summarize, Gia, you shared a lot of helpful information on this. And so the I-140 gives you nothing. But once you are current, according to the visa bulletin, you can file the I-485, and along with that, you can file, which filing the I-485 lets you stay, but you can at the same time file an application for work authorization and an application for travel authorization. So with those, you can work. Once they're approved, you can work and you can travel into and out of the US again while the I-485 is pending, but don't leave until
Yeah.
you have that travel permission, because if you do, you abandon the I-485. Okay, so what about family members? What benefits do they get through an EB2 NIW?
Yeah, so definitely significant benefits because family members, and I define that as your spouse and dependent children under 21 years old and unmarried. They can also qualify for a green card, a U.S. green card, alongside the primary applicants. So this can definitely be a great way to, extend permanent residency status to all of your immediate family.
Excellent. And, a question just came in that I think is a really helpful distinction. So this webinar, we're talking about the EB2 National Interest Waiver. So the National Interest Waiver is kind of a subsection of EB2. EB2 is the second category of employment-based immigrant visas, or also known as green cards. And NIW is just one way to apply for an NIW, for an EB2 immigrant visa. The other way to apply for an EB2 immigrant visa or green card is to have an employer sponsor you. So Jiyae, can you talk a little bit? The question is, I'm a TN visa holder. My employer is thinking about sponsoring me for an EB2. What would I still, why would I still consider an NIW if I have an employer thinking about sponsoring me?
Yeah, that is a great question. So one advantage of self-petitioning for an NIW, well, there are two advantages. The first advantage is timing, in that if you get sponsored by your employer, the employer needs to go through the labor certification process, which could take longer to, which would elongate the timeline until you would have the approval for the green card. So that's one aspect, because the NIW does not require a labor certification process. The second advantage is that by self-petitioning, you are a little bit more flexible on what you can do in the future, in terms of, if you get sponsored by your employer, you need to at least stay with that particular employer for the green card application, and so you are not really in the driver's seat of the application. The employer is really driving the application. So if you're not planning to stay for that employer for long, that can complicate things. But self-petitioning for an NIW, if you're eligible, can really free you up from those ties, because the application is tied to you as opposed to your employer.
Perfect. Thank you, Jiyae. So we do still have a few questions about the procedural side of things. So let's go through these questions real quick, and then we can move on to
Sure.
what documentation we would include in an NIW petition. So the question is, and Jiyae, if you don't mind, I might actually answer this one, since it's a little outside the NIW and more about travel permits.
Yeah, sure thing.
So if you're on an H-1B and you're ready to file your I-485, so whether you're ready to file your I-485 is determined by the visa bulletin, not by what status you have in the US. So let's assume, though, you filed your I-485. You do need to file for advanced parole before you travel. Otherwise, you abandon your I-485. If you need to travel before advanced parole is granted, you must basically get an expedited appointment with your USCIS field office. So if you leave the country before you have advanced parole and you have a pending I-485, you abandon the I-485. So what do you do if you don't have that travel permit, which can take months to get? You would essentially schedule an emergency appointment with your field office, USCIS field office, and you would ask for an emergency travel permission. That's outside the scope of this presentation, so reach out to us through a consultation if you have more questions. Jiyae, so
Yeah.
how long does it take for USCIS to adjudicate an I-140? And if you want, I can look up the processing times if you don't have
Sure.
it fresh off the top of your mind.
Sure. So for the I-140, right? So if you premium process this, they will take 45 days to calendar days to review it. But if you don't use premium processing, then it can take around a year. And Dustin, I don't know what the processing times estimates are right now.
It is a year.
It is a year, right? Yeah. So it will take a year to adjudicate just the I-140 part. Okay, so maybe we can go through the other questions that came up here. So you're still pursuing PhD, will not be on OPT, but will renew the F1 visa as the PhD will take some more time. And so by renewing the F1 visa, if you mean that you're just going to add you're just going to get a new I-20 with a different program ending date, then this will not be impacted by the I-140. No, I don't think, because it is just a matter of you're still in the same program, and you're simply extending the program finishing date. But I mean, yeah, for things like this, I would say definitely schedule a consultation though, so that we can actually look at the documentation.
And Gia, the only thing I would add too is that, if you're in that situation, you want to probably avoid adjusting status within the
Right.
US. And on the application, you would make it clear you're going to apply at a consulate. You're going to choose
Right.
consular processing so that you're required to leave the United States to pursue the immigrant visa.
Exactly.
And then in terms of the TN holder feasibility, feel free to write in if there are specific questions you have about that. But essentially, a TN visa does not allow dual intent, meaning a TN visa, you can't use a TN visa to come into the US and apply for a green card. So if you're on a TN visa and you file an I-140, you might have a hard time renewing your TN visa. So typically you want to have your TN visa set, renew it before you file the I-140. But be aware, as Jiyae was saying before, that each time you enter the US on that TN visa, if you have a pending I-140, you can be asked about your intention to remain in the US. And again, a TN visa, you have to have the intention to leave the US at the end of your status. So Jiyae, why don't we talk a little bit about what is included in an NIW submission? So how long does it take to prepare all the evidence needed for an NIW petition?
Sure thing. And it really depends on how much you focus on it, right? So let's say a client, really focuses on it, is very regular with their processes. I would say on average, it takes around 90 days to prepare all the documentation. And a lot of it's on the client side too, right? So the client would prepare the documents to present the client's endeavor, such as the statement of proposed endeavor. That is a very important part. And you want to make sure that there is sufficient detail in the statement of proposed endeavor to really give the government idea of what you're trying to do. For an entrepreneur, we also highly encourage clients to include a business plan that has, the right information of the projected impact of the business endeavor, including, any financials and hiring plans for the future that can support national importance. Another important part of an NIW submission are expert advisory letters, and expert advisory letters play a very important role because they really contextualize your work and your past achievements in a way that is understandable to the officer of what impact that had or what impact that will have to the industry or society as a whole, and how does it serve national importance. So the NIW is very narrative driven category. So having strong expert letters really help contextualize the work for the officer to better understand. Another thing that could that is required for an NIW petition is records from the applicant's career and evidence that relates to the current project, if the current project has been generating some traction in the industry. So for example, if you have a startup and you have gained admission to accelerator for the startup, you would definitely include documentation confirming the admission. If there has been any investment, you would also include agreements showing such investment to support that your project has been seeing traction. So all of these document collection processes could take some time, and preparing the documents in terms of, the statement of proposed endeavor and the expert letters, that can take some back and forth to adjust the contents. So that would be a big part of the document preparation process.
And so we did get a question. What are the most powerful materials if the petitioner is an employee, such as at Samsung, and does not have patents or publications? What might someone in that situation try to develop for their material?
Without a patent or publication. So definitely reference letters that talk about the impact of the work. So even if the person did not actually author patents, if the person participated in a project where the end result was a publication of a patent, then you can make that link through a reference letter from an insider at Samsung talking about why this person's role was significant on eventually leading to the patent, right? So you can make that that bridge to an achievement that has gotten some industry traction to the person's personal contributions. So that's one way you can do it. So I would say a combination of the end results and the insider letter from Samsung talking about this person's particular personal contribution to the project, even if that person's name is not listed in that patent. So that's one way I would approach that.
Perfect. And did you want to say anything else about what documents are submitted within NIW? I know we talked about expert letters. Anything else that would be on the list that's worth discussing?
So we discussed the business plan. We discussed the evidence of past achievements. And another very important aspect is collecting evidence about your how you meet the threshold requirement for the EB2, right? So if you're meeting the threshold through an advanced degree, definitely get a copy of your diploma for that advanced degree and a transcript showing the relevant coursework that you've done. And also, if it's a foreign degree, definitely include the U.S. education equivalency report, definitely include a copy of that to show that you meet the threshold. If you are meeting the threshold through exceptional ability, you definitely want to go through the checklist and gather evidences of related to the evidentiary criteria. So for example, if you're meeting the threshold through exceptional ability and you're trying to get evidence of 10 years of full-time work experience, you need letters from former employers confirming the hours of work, what your duties were, your salary and things like that, and giving the exact dates that you have worked in to really make sure that they add up to 10 years. And the proof does need to be in the form of letters from employers. So all of these evidentiary considerations would come into play for the threshold requirement.
Great. And let's quickly go over the let's quickly close our presentation by focusing on what entrepreneurs can do to strengthen their applications, and then we'll cover the questions that have any remaining questions that we receive. So Jiyae, why don't we shift gears and look at entrepreneurs specifically, because again, this is an area, the NIW is really beneficial for many people, but especially entrepreneurs, because they can self-petition and they can apply based on a business plan. Where even they don't have an operating business yet, but they have a really well developed idea. So could you share a little bit more about what entrepreneurs can do to strengthen their NIW petition?
Yeah, sure thing. So I do have a couple of tips to share. So my first advice would be really to generate evidence of how your work would not only benefit your immediate clients, but also advance best practices for your field as a whole. And there are several ways you can do this. You can, write research academic articles relating to your know-how and try to get them published in journals. That's one way. You can also try to present as an invited speaker at industry conferences related to your know-how. That can be a good way for people active in the industry. You can also go ahead and take leadership positions in committees in your field, in professional associations. That can be another way to enhance your profile and really show the government that you're doing more than just serving your clients to advance the practices of your industry as a whole. Another way is to, if you're in the tech field, you can develop new technologies and publish patents. All of those things are helpful in showing the government that the impact of your work goes beyond just providing great services or products to your clients. Another thing you could do is, and this also can be done in collaboration with PR agencies. You can try to appear in media interviews and have articles written about you and your work, which really raises the level of public discourse and interest in your work. And this would really work if you're bringing a new and innovative approach to your field that has not really been broadly adopted before. Another thing you could do to strengthen your profile is to participate in government-funded projects, or you can apply for government grants for your work to the extent that they're related to an area that the government is prioritizing. Another way you can strengthen your case is to work with government agencies, trying to see what they need and try to get a letter of support from a government agency. And it doesn't need to be, NASA or something crazy fancy. It can even be a local city agency or a local regional agency, as long as it's related to the work that you're doing and the government can show can afford some support on why your work, your continued work and contributions to the community is of national importance. Another angle an entrepreneur can explore is trying to show that your work as an entrepreneur will result in significant job creation and tax revenues in an economically depressed area. And it is very important to also get proof that the area itself is in fact economically depressed. You can rely on government reports, state level government reports that publish zip codes and maps of counties that are particularly suffering from high unemployment and lower incomes. And you can definitely try to get in a partnership with a local government if it is your endeavor to bring more jobs and bring more revenues to that particular area. So that's another angle you can work on for national importance. Another thing you could consider is to try and get an evaluation from an independent economist confirming your business plan and confirming the indirect, direct, and extended job creation effects that can be related to your business. That can be another powerful way to boost the strength of your profile.
Very helpful. I especially like your point about using local government agencies, because I think they are oftentimes overlooked, and many cities and even towns have like a small business services organization or even an office for immigrant affairs. And if you share with them the work you're planning to do, the impact you're planning to have on the local economy, many of them, I think, would be willing to submit a letter basically saying that we think this would have a positive impact on our area.
Definitely.
And for the NIW, impact is key. So, Jiyae, let's shift and look at a few of the remaining questions we have. And if anyone in the audience wants to send in questions, now is the time to do that. So, the first question, we've been getting this one a lot, surprisingly, or maybe not. But truckers, those who are commercial drivers, can they qualify for an EB2 NIW, and how?
Truck drivers. I think that would be challenging because, right, the EB2 I would think it's challenging because you need to qualify for the EB2 category first, and for that you need an advanced degree, and you need an advanced degree or an exceptional ability in your area of expertise. But I'm not sure if just working as a trucker would lend itself to the evidentiary criteria there. But let's say if you are a manager of a trucking company and you're leading a business and you have an MBA and you're developing this whole new trucking business, and you want to bring a lot of jobs to a specific region in the United States, maybe that is a little bit of a different fact pattern we can think about. But if you're just going to work as one driver, the NIW I don't think would work very well. Yeah, for that, I think the traditional employer sponsorship is the way to go. And there are many different categories of employer sponsorship for immigrant visas. So I would definitely encourage you to look into those.
Absolutely. And Jiyae, while you were speaking, I shared the link to our blog post on pursuing an EB3,
Yeah.
which is an employer-sponsored, excuse me, employer-sponsored green card for drivers. So do check that out. I hope that's helpful. A related question was, can someone who's in the U.S. with a pending asylum application apply for an NIW? I am going to simply reply that that is a very complex area, and we will need to discuss that over a consultation because there are a number of hurdles and obstacles to get over to navigate that appropriately. So feel free to schedule a consultation, which you can do through our website. Jiyae, do
Mhm.
applicants in education, in the education field, have a possibility of being approved for an NIW?
Yeah, so I would say yes, with a caveat, right? So if education, if your proposed endeavor is just limited to teaching your students, that will likely not work very well, right? But if you're developing a new approach in the education field and you're trying to disseminate that approach to a wide variety of education institutions in the United States, in terms of the impact that you can have, if your proposed endeavor is more like that, then I think definitely an NIW could be worth a try, but not if your proposed endeavor will just be limited to teaching your students, because the case matter of Dinosaur specifically discusses the area of teaching, and they specified that if your endeavor is only limited to teaching, then the government would think that this would only benefit the direct students that you are teaching, and such endeavors would not have a broader impact to the society or economy beyond your immediate students. So that's a big caveat that I would remind.
Perfect. And so we just got a question about our legal fees. We have general guidance on our fees on our website. But if you are interested in moving forward, the first step in our process is to send you an engagement letter, and that letter lists all of our fees out and with an explanation of the process. There's no obligation to sign the engagement letter, so if you would like an engagement letter, do reach out to us. Let us know you'd like to move forward. Jiyae, do we write the reference letters as part of our package of support?
Yes, there is an option. You have to pay extra, and we charge quite a hefty price for that. But we can definitely explore that. Yes, so that is an option. But we only write the letters based on the information you provide. So you do need to do some legwork on your end as well. There is a question on RFE of an EB2 NIW, and yes, we do take such cases. We would just bill hourly. So any time we spend on the RFE, we would be billing on our hourly rates. So there is no set fee for that, but we have taken those cases before.
Great. And what about accountants and auditors? Any chance of getting an NIW?
Yeah, so similar to what I shared with the educator example, for accountants and auditors, if your proposed endeavor is only limited to providing great services to your clients, that will unfortunately not be enough to qualify for an NIW. The NIW really works best if you can show that you are bringing a novel approach to the field of accounting as a whole, or to the field of auditing as a whole, and that can be shown by your participation in industry conferences, publication of articles in your field that has gotten some traction, things like that, where you're sharing your unique insight that cannot be found in the general body of auditors and accountants. That would be a better case for an NIW. Whereas if your services are limited to just benefiting your clients, that will be a challenge.
Absolutely. And Jiyae, I think in that response, you really hit on a very important point, which is that unless you already qualify for an NIW. An NIW could be a long-term goal. And so especially if you're in one of these fields that tends to be focused on, say, teaching or accounting, where you are providing services to a small group of clients. So, it could be a good idea to start developing yourself as a professional by, for example, publishing, by attending industry conferences, getting opportunities to speak at conferences, maybe starting a website where you publish innovative ideas and thoughts and start engaging with the public through that medium, but really developing your record, your evidence to show that you go beyond a typical accountant, and you actually are a voice in your industry where you're
Right.
having a broader impact. And I think for many industries, it's actually a great goal to have, to develop yourself professionally, but especially if your goal is to apply for an NIW. So we
Yeah,
only have
great
1
point.
minute left, and so we'll answer this question. For STEM fields, science, tech, engineering, math, is it easier to qualify for an NIW?
Yeah, so with the 2022 policy manual updates, if you have an advanced degree in STEM that is related to a critical and emerging area that the US government is focusing on, I do think, yes, that poses a significant advantage. But do note that your endeavor must have that, a broader impact. Well, your endeavor must be something where we can expect broader impacts, right? So if you engage in research, for example, where the results would be disseminated to the industry, that is typically a very good angle you can have. But if you're just, providing software engineering for one employer, that kind of endeavor will not be as advantageous. So definitely it is also a fact specific inquiry. So I wouldn't say that STEM is 100% easier, but definitely, yeah. But depending on your proposed endeavor, it can certainly be an advantage.
Great, and Jiyae, you're making quite an impression here. So does Jiyae have capacity to take on a new case, and can we request her specifically? You can
Yes.
certainly request Jiyae. We do have capacity for more cases. So do reach out if you're interested in moving forward. All right, it is 1 minute after 1 o'clock our time. So thank you all for the great questions. Very lively discussion and excellent questions. Jiyae, thank you for sharing
Thank
your
you.
expertise. Keep an eye out, everyone, for our follow-up email. We will share more information on where you can sign up for future webinars, watch the recording and other recordings. So please don't hesitate to reach out if we can be of any help. Jiyae, thank you again.
Thanks, Dustin. Have a good one, everyone.
Bye-bye.